slideshow of photos from the 3 law centres, which I'm sure was a trip down memory lane for some. While I can't see you, it's great to know that we have here with us some current and past volunteers, board and staff members, some of whom, like our clinic administrator Kathleen, have been with CLM for a very long time. We are also delighted to welcome a number of councillors and TDs, our colleagues in other law centres, advocacy organisations, law firms and universities, as well as our funders who have supported our work over the years. I'm very grateful to be joined on the panel today by Sean Canning and Ursula O'Hare. Sean, who is originally from Derry, but who has lived in London for over 30 years, originally worked in social housing and homelessness charities before training as a solicitor in the 90s. Sean initially worked as director of North Kensington Law Centre, and since then he splits his time between Camden and Hackney Community Law Centres, where he currently serves as director. Ursula joined Law Centre Northern Ireland in 2006 to establish a policy unit to advocate for law and policy change grounded in their legal advice and casework experience, becoming director of the Law Centre in 2017. Ursula was independent chair of the Department of Health's Legislative Reference Group on the development of a new mental health capacity legislation in Northern Ireland, and led the Mental Health and Learning Disability Alliance to campaign for progressive mental health and capacity law reform in Northern Ireland. While there are some differences, both law centres do similar work and are of a similar vintage to CLM, and I'm very much looking forward to today's discussion on progress made in the last 45 years and the challenges that remain for law centres in the communities we work with. I'm also grateful to our moderator today, Colin Daly. Colin is the President of the District Court and was formerly the Managing Solicitor of Northside Community Law Centre, as CLM was then known, from 2001 to 2012. Colin, to you.
Hello, and good morning. Thank you for the introduction, Rose, and a very big welcome to all the participants today at this really appropriate webinar. I believe that there's 120 participants registered to take part today. Unfortunately, we can't see you, but you have the pleasure of seeing us, I believe. And we're delighted to welcome so many familiar faces, so many people who know the work of the Law Centre in Coolock, but also to welcome people from Northern Ireland and also from England who may be joining us today too. The first job that I have today is a really pleasurable job, and that's to congratulate Community Law and Mediation on its 45th anniversary. The Law Centre was established by FLAC back in 1975, and during the intervening 45 years, the Law Centre has played an extremely important role in public interest law in Ireland during the course of that time. And of course, a very large part of my professional career was spent at the Law Centre, and it occupies a very special part in my life. So that's why it's an extraordinary pleasure to be invited here to be part of this with you today. Over the years, the Law Centre's had many names: Coolock Community Law Centre, when Dave Ellis and Roisin Connolly were the incumbents, Northside Community Law Centre when I had the privilege of working there, and now Community Law and Mediation with Rose as its CEO, and so many of the staff that were there when I was there also. We're all proud to have played a small part in the history of the Law Centre. And we're going to hear about some of that history today from Rose. I suppose just to take a minute to reflect, because we have 2 other law centres represented here today as well. And we know that law centres emerged from the United States in the 1960s. And depending on where you find yourself, they have slightly different names. There's law centres, there's community law centres, there's neighbourhood law centres, and there's community legal centres. And in different parts of the world, these names might be used. But whatever names you use, or whatever way you look at it, all of these centres have some very important things in common. They all are not-for-profits. They all work with those who are distanced from the law, and they are resources for helping these people who are distanced from the law, for claiming their rights under the law. They work in areas of law that are often not popular and certainly not profitable, but they all use the law as a tool to effect social change. So whatever you call these centres, they occupy an extremely important place in the legal landscape and in the social landscape of the communities that they serve. So today, community law and mediation is the middle child, and we're joined by their older sibling and their younger sibling. And so there might be a riot between the three sibling groups today. We have Ursula O'Hare, who's going to speak on behalf of the Law Centre of Northern Ireland, the younger sibling. I won't call you the troublemaker, Ursula, but you might occupy that space yourself later on. And also we have Sean Canning, who's coming from Camden and Hackney Community Law Centres, the older sibling of the sibling group. So I hope you're not going to take that traditional role of trying to boss everybody around. Over the next hour or so, we're going to have a chat about the focus of the law centres, their work, the challenges that they've faced over the years, their successes in the past, the challenges in the present, and also perhaps the opportunities or the way things might work in the future. We have maybe 20-25 minutes for each of the three sections that we're going to cover today. So I'm going to ask that each panelist try to keep your contributions to around the 5-6 minute mark. And I'm also going to ask you for forgiveness in advance if I do prompt you to move along, so that we can hear everybody and move through the various parts of the discussion that we want to have today. The viewers that are participating in this discussion today, you'll have an opportunity also to leave your comments, which will be seen by the panel. We don't have time today, unfortunately, for a questions and answers type approach, but I will be moderating, or I'll be seeing the comments as they come in, and I'll certainly try to incorporate those at the conclusion of the panel discussion today. So without any further delay then, the first part of our discussion, the question that I'm going to pose to the panel is, what have been the highlights over the past 45 years or so for your law centre, and what are the main areas of progress that you have seen or that your law centre has seen over that time? And I'm going to ask you, Rose, first of all, if you'd like to make your observations to us.
Thank you, Colin. So I suppose looking at highlights first, over the past 45 years, there are many, but they broadly include our setup and survival, our growth, and then the difference we've made to people's lives. In terms of our setup and survival, Coolock Community Law Centre, as we were then known, as you said, Colin, was set up in 1975 by FLAC as the first independent community-based law centre in Ireland. As part of the campaign for civil legal aid, which did not then exist, CLM originally served as a prototype of the neighbourhood or community law centre that could underpin a nationwide civil legal aid scheme. As you saw from the slideshow, there have been many instances in our 45 years where our funding was seriously under threat, the first of which was in 1980 when we survived only on fees we received from the Stardust Tribunal, and the most recent of which was in 2009. And I would see the survival of these threats helped by the support of and representations from the community we work with as an achievement in and of itself. In terms of growth, one of CLM's core values is innovation, and our first strategic objective is to identify and meet unmet legal needs in the community. Now that need constantly changes, and we've always tried since we first opened our doors in 1975 in a small windowless office in the Northside Shopping Centre in Coolock to adapt to meet that need. Dave Ellis, who Colin mentioned, who was with CLM for over 20 years, almost from the start, and whose name is synonymous with the Community Law Centre movement, really led the work of the centre through the 80s and 90s. And under his and others' watch, services were expanded to include community engagement, education, and law reform campaigns in areas which we have seen progress in, such as disability rights, divorce, domestic violence, and social welfare reform. With the latter, I was told recently, spearheaded by the Welfare Rights Group, which initially consisted of meetings in Bewley's with Dave Ellis, Mike Gallen and Mel Cousins, some of whom are with us here today. Under our moderator Colin Daly's stewardship, this continuous innovation of our service to meet the need of the community continued with the establishment of the mediation service in 2004 to address the need for an alternative dispute resolution process to the legal system for private disputes between family members, neighbours and colleagues, where it is vital that good relationships are preserved and parties are enabled to take important decisions over matters which affect their lives. In 2012, we set up CLM Limerick, which is the first community law centre outside Dublin, in response to representations made by Limerick-based community representatives and activists. Since 1975, our services have broadened beyond the original catchment area of Coolock and are now provided to anyone who, because of economic, social or other disadvantage, are unable to access the services that CLM provides. In terms of the difference that CLM has made to people's lives, in the early 80s, CLM represented families of the Stardust victims and took important cases in areas such as social welfare, such as the McConnell versus the Eastern Health Board case in 1981, which held that social welfare applicants were entitled to have access to details of the case against them in advance. There are many other case successes which led to changes and clarifications of the law, and in more recent times, the McCann case, where CLM successfully challenged the constitutionality of the law under which a person could be sent to prison over failure to pay a debt, with the relevant remedying legislation now providing that an order for imprisonment can only be made where it has been shown that a debtor's failure to make repayments is due to willful refusal rather than an inability to pay. Another well-known success was the Pullen case, which declared the summary eviction procedure set out in Section 62 of the Housing Act 1966 incompatible with the European Convention on Human Rights, ordering damages to the plaintiffs for breach of their rights under the Convention. Apart from the big cases, there are many cases we take, about 3,000 a year, which are resolved through mediation or at pre-litigation or pre-hearing stage, but nonetheless have a significant impact for the person involved. Now, it's easy to lose a sense of the individual and human story behind a figure like 3,000, but one story is Kathy's. So Kathy, like many recently, came to CLM in relation to an employment issue. She had been a very loyal employee for 35 years and assisted with arranging redundancy payments for other staff when the company began to go into decline. The managing director came into her office one day and told her that the company was closing the following day and that there was no money left to pay her redundancy. She was understandably devastated and applied for redundancy payment to the Department of Social Protection, and after waiting many months for a decision, was refused. We wrote to the department on Kathy's behalf, pointing out that their decision was incorrect, and also lodged a complaint to the WRC. After further contact with the department, the decision was reviewed and she received the total amount due to her. Kathy said that when she attended our clinic, she had given up any hope of getting anything. She described our service as being like a life buoy and told us that we will never know the difference that it made to her. So a lot has been achieved through the work of the Law Centre, and I believe the existence of the Community Law Centre model, not just in CLM, but also in our colleagues in the Ballymun Community Law Centre, is really important. However, there are challenges that existed in 1975 still remaining, some arguably bigger now than they were then. The first significant challenge which we see is the housing crisis, which has seen many families and individuals homeless and experiencing difficulties accessing housing which is adequate to their needs. Housing is one of CLM's biggest practice areas, particularly in our Limerick office, and we assist families accessing emergency accommodation on the housing list, with young people leaving state care still extremely vulnerable to homelessness. We also assist clients, including members of the travelling community, living in what can only be described as appalling conditions, to address those conditions. There are many other challenges and areas of reform needed that I could talk about, like, for example, the fact that the Assisted Decision-Making Capacity Act still hasn't been commenced. But the reality is that all of these law reforms that have happened or have yet to happen are not enough on their own without adequate legal aid. We know from Susan Gogan's research in Ballymun in 2005 and CLM's research in Limerick in 2012 that access to legal aid is not a reality for many in our community. CLM was originally set up as part of the campaign for the introduction of a comprehensive model of civil legal aid. This has not been introduced. The current scheme is under-resourced with significant waiting list. It is overly limited in scope as it excludes from its remit social welfare and employment and equality cases. Its financial means test is overly restrictive and out of step with the current cost of living. And the model is a service model rather than a community law centre model, and so does not include community engagement or education and law reform, which we would view as critical. Minister McEntee has recently committed to reviewing the legal aid scheme, something which we and others in attendance here today would very much welcome. The fact that many in our community still do not have access to justice means that the legal protections introduced since 1975, for example, in the area of employment and equality, are not enjoyed by all. To paraphrase one of my favourite quotes from American attorney Kimberly Motley, the laws are ours, they belong to us, and they need to be used. If people don't know about their rights under the law, don't know how to assert their rights, or are not able without legal assistance to do so, then those rights aren't being protected.
Great. Rose, thank you very much for that whistle-stop tour through 45 years at the Law Centre in Coolock. Sean, I'm going to ask you the same question. Your experience in London, and in particular in the law centres in Camden and Hackney, what do you think have been the highlights over the past 45 or slightly more years for your law centres?
Well, first of all, thank you for inviting me to speak on what's an historic milestone for CLM. I've been responsible for organising similar events, so I know the amount of preparation that goes into these, and it's even more of an achievement during the current pandemic. But turning to our main achievements, I think, I mean, the first law centre is actually started 50 years ago this year, in 1970, with North Kensington Law Centre. But I suppose what encapsulates our movement is that we exist to give a voice to the voiceless, and whether that's acting for tenants against unscrupulous landlords, bad or unscrupulous employers, and holding the state to account by challenging the decisions of public bodies. I think it's fair to say what the common theme that certainly drove the origins of movement were housing, really, and certainly the lack of housing rights, particularly in London, and equally, as Rose has just alluded to, it was certainly instrumental in the origins of CLM. And I think housing was one of the main things that certainly drove the initial founders, the lack of satisfactory housing, poor conditions, particularly in North Kensington. And that story was equally applied in Camden, high levels of unlawful eviction by unscrupulous landlords. But I think if you just kind of broaden that out, I mean, the whole issue of structural inequality kind of underlies the much of the casework that we've dealt with in the last 45 years. I think, you know, from housing, developing the housing duty scheme, which was a real milestone in ensuring that unrepresented tenants had a voice in the courts, basically. And that kind of extended out to employment, helping the lowest paid, vulnerable employees working very often on satisfactory conditions. And particularly in Camden, I think in the early days, because of its geography, it was home to a very large clothing trade, where lots of workers were subject to appalling working conditions. Most of them were kind of minority, most of them women, Bangladeshi nationals, who had no proper contracts for employment, were not paid proper wages, and were just dismissed without any notice. I think law centres were kind of instrumental in challenging that, and that kind of extended to you know, the hostile environment that we now talk about, but it was equally prevalent back then in the area of immigration. Certainly as the British government back in the 70s started to curtail the movement of British citizens, there was that impacted significantly on Commonwealth nationals coming into the UK. And law centres were very instrumental in challenging some of the attitudes and the policies of the Home Office, which were rather frank racist. But I think through the campaigning work and the casework of our movement, we were instrumental in developing a whole, I would say, a rights-based jurisprudence around what we would call broadly social welfare law, which embraces housing, employment and welfare benefits, and asylum and immigration to some extent. It gave rise to a whole body of statutes, such as the Homeless Persons Act in the UK, which placed the duty of local authorities to investigate its responsibilities towards people who might be deemed in priority need or vulnerable. We also had the Human Rights Act, and then the various forms of equality legislation culminating in the Equality Act of 2010. And then we had the Employment Rights Act, and later in the 90s, in 2000s, we had the Minimum Wage and the Working Time Directive. These were all positive achievements that certainly were championed by the original founders of our movement. And then what kind of encapsulates these, I think, is that they were about promoting access to justice. I mean, if you want to define the core mission, that is what it's about. Ensuring that there's a better awareness of rights and enforcement, enhancing the quality of people's lives, dealing with the most kind of vulnerable groups in society if you're not able to articulate or access the system. I think there's two cases that probably encapsulate that principle of access to justice in recent years. One was an employment case and the other was a housing case. The employment case was litigated in the Supreme Court in 2017. It's known as the Unison case, brought by the trade union on behalf of its members. And what it was to determine the principle of access to justice and whether it had been impacted by the government's decision to bring in fees for employment tribunal claimants, which had a huge detrimental impact. I mean, as you may be aware, at the beginning of the last decade, the government brought in huge cuts to the public services and legal aid and introduced very steep fees across the court system. This impacted significantly employees because what it meant is that people were deterred or put off from making any application to the employment tribunal. Unsurprisingly, the volume of applications to the tribunal went to the floor and they dropped by something like 80% within a space of 12 months. But interestingly, this case was litigated and to challenge the whole legality of those fees on the basis of them, they've impacted on the access to justice. And the defining judgment given by Lord Reid basically articulated that the whole fee system, as it was constructed, was contrary to common law and EU law. But particularly important for our movement was that they set out how they define what they mean by access to justice. And access to justice is a famous paragraph in that case, paragraph 66-67, whereby the courts basically said that access to the courts, and this principle applies in Ireland as regard and any other jurisdiction, is an inherent principle of the rule of law. And in order for the courts to fulfill that function, people must have unimpeded access to them. And without such access, the law becomes a dead letter and the whole role of Parliament is rendered worthless, basically. And I think critically what they attacked was the administration of justice, which kind of focused on treating the justice system as a public service and the people who access the courts as merely users of the service. And what the courts were basically saying that access to justice is a fundamental, it's an inherent part of our system as a society. The second case was the judicial review brought by the Law Centres Network.
John, I'm going to interrupt you. I think that the highlight of the Union case is a really good place to maybe move the conversation on to Ursula, because that point of access to justice and access to justice for all and how that makes the law meaningful, I think is a really good place to perhaps conclude. Thank you. Ursula, I'm going to put the same question to you. For the Law Centre in Northern Ireland, what have been your highlights? The areas of progress, the areas of challenge over your lifetime of almost 45 years.
So, as the youngest sibling, as the baby on the block, Colin, you said you hoped we weren't going to be disruptive, but well, actually, law centres are a stand for a world that works for everyone, aren't they? And to make that possible, sometimes a bit of disruption is called for, but I promise I won't be disruptive this morning. Listen, thanks for having us here today. We're looking forward to our 45th and our 50th and forward. So we are the New Kids on the Block, set up in 1977. And when I was reflecting on the conversation we were to have this morning, what really struck me was that our origins actually go back to 71, when the Association of Local Community Advice Centres started to talk about the need to find ways to use law to leverage change. And what's fascinating is we were actually set up and funded by the Northern Ireland office as a 2-year experiment. And here we are. So the first thing I want to say in terms of a highlight is survival and resilience. Rose already spoke about that and Sean knows that well. I had a quick look last night at our very first, what we'd now call an impact report, but our very first annual report, which covered the 2-year period, that pilot period of 77 to 79. And it opens with the heading, that the Law Centre, which was then called the Belfast Community Law Centre, was about creating a different kind of legal service. And I said there were two things it was about. And the first was that the aim was to discover the most effective means, I am quoting, of providing legal services to people with problems who previously haven't had access to law as a means of redress. But the second thing it said, and this is really important in terms of what I think is a highlight for the Law Centre movement as a whole, is it said that it was never envisaged to be purely casework. It wasn't going to be just a casework agency. It recognised back in the 70s that education, training and public legal information were critically important. And so that process has just continued to evolve over the years. And for me, one of the highlights has been actually, and continues to be, that the model that we all apply to our work, it's not simply advice. Advice is important, and it's not of itself sufficient to create that world that works for everyone and to create access to justice. It needs advice, it needs referrals, it needs connection to community, it needs law in community. It needs the casework, it needs the strategic litigation, but it critically needs the information, training. And one of the things that's really close to my heart, because it's kind of how I came to all of this, is it needs ways of creating the next generation of social justice lawyers. And what's already emerged, and you saw that so beautifully captured in those photographs, is the absolute centrality of campaigning and law reform and policy work. So the first thing I would say in terms of highlight is survival and resilience. The second thing I would say is that the model that we apply to doing law is hugely powerful and can and does bring about systemic change. And the third thing I would say as a highlight for us over the years has been that I think it has been possible to create a greater equality of arms, because I think the existence of law centres creates a space within which social welfare law lives and breathes. You know, when we first opened our doors back in the 70s, and it was in a little office up around the university, basically the Law Centre, as it was then Belfast Community Law Centre, took whatever came through the door. And so it started in immigration work because in 79, a couple of Iranian students literally came through the door. Their country was in turmoil and were seeking asylum and needed help. We were doing debt work, we were doing housing work, we were doing consumer work, we were doing whatever came through the door. And over the years, that has definitely changed. And certainly our Law Centre has put a focus on key areas of social welfare law. So we didn't set out to start, for example, doing immigration law. It was really focused on social security law, but we moved into immigration law. Then in the noughties, late 90s, early noughties, we started doing trafficking work. So it's about law centres responding to need. And mental health law and capacity law became then hugely important in the noughties and beyond. And I think, and particularly perhaps during the period of conflict in the North, I think the shining a light on the importance of economic, social and cultural rights has been hugely important. And I think using international human rights standards, Sean's already talked about the Human Rights Act, and maybe we'll come back to that when we look at future challenges. But using international standards and bringing them into day-to-day work, I think has been hugely important. I do think the public information, the training work has mattered. We all recognize that there's, people need to know and understand what their rights and their entitlements are before they can start to do anything with them. So I think that's been really important. I think the impact of campaigns has been and continues to be really important. I mean, I talked in the 80s, it was benefit uptake campaigns, it was housing repair campaigns, it was debt campaigns, challenging emergency legislation that was put in place because of the conflict to deal with the application of debt policy. In the 90s, it became a campaign around the detention of asylum seekers. And today's campaigning is largely around a social security system that needs to work better. Where too many people are falling through the gaps and where we are seeing a relentless rise in poverty here. And I think the impact of working to develop the next generation of social justice lawyers has borne fruit for us as a law centre. So we had with generous funding from one of our funders then, it was Atlantic, we set up a legal support project that started to bring volunteers and students in to start to try and develop a culture of pro bono work and to create a pathway for the future social justice lawyers. And there's been a real legacy of that, because some of those people who started out as the volunteers are now our members of the team, they're members of staff. But not just that, they are scattered everywhere in legal practice and in community contexts and in community organizations here, and that's been hugely important. And I think that the late kid to the block was the policy work. You know, we'd always tried to engage in that law reform work, but you know, any of the lawyers in the call will know that, you know, if you're making a call between writing your policy paper and the casework that needs done that day, the casework wins hands down. And so the reason I joined the Law Centre was to create the space for that policy work to really emerge. And I think that's been and continues to be really important going forward. But at the end of the day, fundamentally, it's the impact on people. And some of that's achieved through, you know, the big strategic litigation cases, you know, so I mean, there was a judicial review we took a few years ago now, but it was about ending the practice where somebody was living in a long stay learning disability hospital and that was their home address. So getting resettlement within community, that's you know, one example. Cross-border social security cases have been a common thread since the 90s, will continue to be. A couple of cases that have just concluded in the last couple of months, social security cases for Lorraine Cox, who has a diagnosis of a terminal illness, but because her diagnosis could not be accurately determined within 6 months, she was precluded from special rules that would have lifted a number of restrictions in terms of her ability to access benefits. There's been a positive outcome there. So it's really the impact on people, both at a strategic case law level that has the wider impact, but actually just, you know, it's impossible really to capture, as Rose said, the day-to-day impact, the day-to-day difference that I think the work that everybody here together does.
Ursula, I think that's a really positive note on which to conclude the first part of the conversation. And it's probably, you know, the biggest success of the law centres over the last 45, 50 years is the impact that the work of the law centres have had on all of those many thousands of individuals who have come through the doors of law centres in Ireland, in Northern Ireland and in the United Kingdom. And the transformative effect that having access to law as a remedy for putting right the wrongs that they have experienced is so important. So I think if anything encapsulates the successes or the highlights over the last 5 decades, really, that's what it is. So if we've looked at the past, let's start now to look at the future, to look at the present, and to look at the current challenges. We're having this event online today rather than sitting in a lovely hotel somewhere with a big ballroom full of all of the friends and supporters of the law centres throughout the 3 jurisdictions. We're having it online. People are participating from their own homes or from their workplaces. And I suppose this really highlights the extraordinary way that we've had to change and adapt over the last 8-9 months. So, you know, in the present challenges, how have the law centres responded? What lessons have you learned? And Sean, I'm going to ask you to join in first of all on this point, and then I'll come to our other panelists.
Thank you. Well, I think, as you've alluded to, clearly we've all had to adjust to a new normal way of working, I suppose. And certainly the COVID certainly brought out into the open, into much more sharper focus, the deep structural inequalities that exist in society, because we've all bring different experiences of COVID to us, and I think it's impacted disproportionately upon those who are at the lower end of the socioeconomic structure. And certainly from an operational point of view, we've all had to adapt to working remotely and online. And whilst this brings opportunities in terms of an organization, certainly for the clients that we work with, it's been a real struggle, I think. And many clients, certainly the ones that we deal with, have struggled with the whole access, the digital access. And lots of people who are digitally excluded might know how to use a mobile phone, but they really struggle with online working. Lots of government services are now transacted online, particularly the DWP in the UK, so benefits is all online, which is a real struggle for people. And clearly, trying to help the most vulnerable during lockdown has been a challenge. We've all been working remotely, so lots of assistance has been done via telephone and where possible over these kind of forums. But I've certainly noticed in the volume of our cases been a surge of domestic violence during lockdown, unsurprisingly. That has created a huge increase in demand and has put pressures on families, as we all know. The courts themselves have been closed, so that has been difficult. Obviously, you have to kind of adjust to a different system of working. And whilst professionals like ourselves can adapt, it's not always, the court system isn't always tailored to the needs of the end user, the clients. In certain types of cases, as we know, are probably not really suitable to be heard over a Zoom connection, basically. And I think long-term impact of austerity, I think, we're going to see the huge rise in debt and high levels of poor health, community care. Certainly, not unsurprisingly, our services have been inundated with employment. Employment fallout from COVID has been enormous. And once the government in the UK has put in place support schemes through the furlough system, there is a big avalanche coming down, and we're starting to see that in terms of the volume of calls. Unsurprisingly, that impacts on us as an organization because clearly, as has been alluded to earlier, funding has always been a challenge for our sector. So financial sustainability going forward is a real issue in terms of loss of income. Lots of charities, lots of the big funders have not really publish their programs for the next year or so. So we really don't know where we're going to be. This year, the UK government's quite generous. We have had some funding, but my guess is that the real impact of this is going to be in the next 2 years as the government attempts to grapple with the public finances carnage. And that will no doubt impact on the most vulnerable members of the community who require our services. I think that just in passing, I think it's fair to say that whilst there's benefits of working remotely and having a courts and justice system that engage with the new technology, I think we need to be aware that we need to look at how we can prevent problems escalating and try and structure services so that the more they take into account the needs of users. I think very often in our attempts to certainly what COVID's highlighted is that there are lots of people who are excluded from the current system, and the whole focus of access to justice has been really brought into the domain because lots of people will be excluded as a result of the impact of COVID. We're seeing that already. I don't want to go on about Brexit or anything like that, but basically the whole there's going to be huge fallout. Demands for our services already peaked, and I think it's going to only increase as in the next couple of years. And that alongside the impact on our own organisation in terms of us as managers trying to maintain financial sustainability. But as been said earlier, one thing we are is resilient, and that's we've demonstrated that numerous occasions over the last 40, 50 years. So there you are.
Very good. Thank you. And Ursula, I'm going to invite you to come in now, and perhaps you'd like to share with us how the Law Centre Northern Ireland has responded to the community need during COVID-19, and perhaps, you know, are there some adaptations that you've made that you think will last post COVID-19, if we ever get to that point?
When we get to that point,
Very good.
yes, I think there are some things that will just continue to be a feature of how we all work going forward. I want to echo what Sean said about that. We have experienced a massive spike in demand for employment law support, and that's not surprising. But I don't think we are anywhere near like reaching a plateau on that, because whilst the UK Chancellor has extended the furlough scheme to the end of March, all that's really doing is kicking down the road somewhere. What is likely to be then a tsunami of you know, potential redundancies at a later stage. To agree with Sean, you know, this pandemic has really highlighted the structural inequalities across society. One of the ways that we've tried to respond to that in terms of service is to look at our service design, our service, how do we deliver services within community. We are largely a telephony-based service. And one of the things we've done is put in place email channels for people to come to us to get advice. And we know that that's not enough, because as Sean said, you know, we are worried about people who are not, who don't have the capability for whatever reason to use those channels effectively. One of the groups that we would be particularly, I think, kind of worried about is, you know, might be some of our, some clients for whom, and including our immigration clients, it's how do you have a private client consultation, for example, if you don't have a private or a safe space within which to do that. So whereas in the past, just before the pandemic actually hit, we were doing, you know, a clinic within a local community context. How do you find new ways to do that? So we're constantly looking at how do we redesign the service in order to meet need, and I think that will continue to be a feature of our work going forward. Some of the things we're worried about as well is there's a very significant backlog in tribunal claims here. So, you know, it's been possible to progress the judicial review type work through the higher courts over this period, but the first tier social security tribunals really haven't progressed. And so what we've now got is a significant backlog in those cases. And what we're starting to wonder is, so they've literally just started hearings again. So what does a future of remote justice, which I think will be an element and an aspect of the future for us all, what does that look like? And what does that look like for different groups? Certainly some of the delays around getting work and getting people's cases progressed and finalized, I think has had a detrimental impact on a number of our clients for all of the obvious reasons. So we are looking, it's almost like it's a constant process of reflection and looking at how do we, and now what do we say is called for and what's called for now. So we're constantly asking ourselves that question, and what's called for now, because we know that this situation has created a space where not everyone's able to use the services in the way they would have. And going forward, I think we will have a much, I mean, the word is blended, isn't it? I hear that from my kids when they come home from school and talk about blended learning. There's going to have to be a whole range of pathways and avenues through which people can access justice and use their law centre going forward. There are some of the things we're worried about just at the moment. And then I guess the spike in social security challenges, because there's been a massive increase in the number of people who are now within the social security system who wouldn't have previously had experience of that system. So we're anticipating that there'll be a shift there as well over coming months.
Okay, that's really interesting that the needs, or where you're seeing spikes in needs, but also reflecting on that piece about flexibility of being able to respond to community needs within the challenges that the external environment is going to impose in the short term and perhaps into the more medium or long term. That's really some very useful reflections. Thank you, Ursula. And Rose, I'm going to come to you now, and I'm going to ask you, I'm sure at CLM you found ways to more effectively engage with communities in the current challenges. You might describe those to us, and do you see those as being ways that will stay? Will they be blended, as Ursula says, into how you're going to provide new services in the immediate future?
Yeah, and I suppose before I answer that question, I think it's important to kind of look at what COVID has shown us about how we live and how our society is. And for us, it's really thrown into sharp relief the deep inequalities that exist in our society. And the Italian novelist Francesca Melandri made an interesting comment about it that I think is worth quoting. She said, "Class will make all the difference. Being locked up in a house with a pretty garden or in an overcrowded housing project will not be the same, nor is being able to keep on working from home or seeing your job disappear. That boat in which you'll be sailing in order to defeat the epidemic will not look the same to everyone, nor is it actually the same for everyone. It never was." So in terms of our response over the last 8 months or so, we have started providing 11 weekly free legal advice clinics by phone. And we've seen, as Ursula mentioned, we've seen a significant increase in the number of employment queries in particular, but also housing too. And we've seen that the current situation is exacerbating existing difficulties. We're hearing stories of people losing their jobs, of job offers being rescinded and contract terms unilaterally changed, of increased violence in the home, of difficulties paying rent and other bills, and of barriers accessing social welfare payments. We also moved our mediation service online. With the increased pressure faced by families due to restrictions, financial difficulties, and other worries, this service has been needed now more than ever. I suppose another impact of restrictions has been the increase in already long waiting lists for essential social and other services, including the courts, the family mediation service, and legal aid. These services are so critical for the individuals and groups that we work with who experience in poverty, social exclusion, and inequality. And thankfully, the schools have reopened, but their initial closure created real hardship for children and families experiencing disadvantage, as well as increased child protection concerns. There has been some positive kind of silver linings around it, as Ursula mentioned, the kind of blended approach and the forced innovation that's happened. And that's happened within CLM too. So we've moved, as I said, all of our services online and to the phone. And while this has made the service more accessible for some, particularly in our case, for people who don't live in Dublin or in Limerick, it is definitely less accessible for others. And particularly the hard to reach groups where there are issues of digital poverty, but where there's also a lack of awareness that the law can assist if, for example, they're homeless or can't access social welfare. So our service is currently working really well for somebody who knows that they have an issue that a solicitor can assist with, and they know that they can pick up the phone or go online to get that assistance. But for others, it's not as straightforward as that. And our model, the Community Law Centre, that accessible outreach, where community education, community empowerment, community engagement is really critical, is certainly missing because of the current restrictions. But another kind of innovation and positive is the introduction of virtual hearings in some courts and tribunals in an effort to adapt to COVID restrictions. And it's to be broadly welcomed given the potential of digital technology to introduce efficiencies into our court and to deal with mounting waiting lists. However, the use of virtual hearings and other technologies must not exacerbate what can already be a difficult and frustrating experience for some. So supports must be provided to ensure that anyone who participates in a virtual process can do so effectively. And the use of virtual hearings, it's going to be a new departure for all involved, but it's going to be particularly daunting for those who don't have legal representation and who might have other vulnerabilities. So people with intellectual disabilities or people for whom English is not their first language. So consideration, we feel, should be given to the suitability of cases being considered for virtual hearings and looking at, I suppose, the availability of IT, the availability of broadband, but also the need for supports for certain people. I think in terms of the lessons learned over the last 8 months and in terms of moving forward, I think keeping that innovation while also bearing in mind the specific needs and vulnerabilities of individuals and groups is really important. But I think a further lesson has to be learned from our initial response to the crisis, where some extraordinary measures were introduced for defined periods. So if you remember, mortgage payments were suspended, rental increases were frozen and evictions prohibited, a single-tier health system was introduced, as were employment supports and enhanced social welfare payments. There was a provision of significant number of additional bed spaces and off-site self-isolation facilities for asylum seekers in direct provision centres, as well as the provision of 24-hour accommodation for many homeless people. These changes, which are aimed at protecting those at risk of eviction, job loss, debt, inaccessible health services, or increased risk of contracting COVID, were really nothing short of remarkable. And I think in looking at how we rebuild society post-COVID, we have to keep that sense of ambition, that sense of imagination, and that sense of fairness to make sure that we protect vulnerable people going forward. Okay.
There's certainly a challenge for the future that we've learned from the experience of the last 9 months, and I suppose it's a really positive way to conclude that conversation about how things have transpired over the particularly challenging months that we've all just lived through and are continuing to live through. We're now moving on to the third part of our discussion, and in the third part of the discussion, we're going to look to the future and to see what your visions are with regard to what the future might hold, and what the biggest challenges that law centres, community law centres, might face in the years to come. You've celebrated 5 decades, and over the next 5 decades, then what do you think might happen? What role do you see law centres playing and in meeting those challenges? And Ursula, I'll invite you to answer that question first of all this time.
So, as always, lots of challenges. And if there's a big message from today, it's resilience, isn't it? And survival and tenacity in the face of those challenges. So I just want to pick up maybe in terms of what law centres can do going forward in the face of all of the challenges, which maybe I'll say something about in just a second. But it's to pick up on what Rose just said. This period has shown us what can be done. You know, we make choices as a society about what we choose to afford. You know, we can afford what we choose to afford as a society. This period has shown, I mean, so here there have been some significant easements around the social security system. There are already some mitigations in place in relation to the big changes to the social security system that have taken place in the last 10 years. Sean talked about the furlough scheme that was put in place. It is possible for us to create and imagine a different world. And I think one of the things that law centres are great at doing is reflecting back to decision makers what the impact of their choices are. And I think we have something to say and something to do there. There are lots of challenges ahead for sure. I mean, Sean already referenced Brexit, threats to the Human Rights Act. So those important foundational structures that hold the work that law centres do. Poverty is unrelenting, and the level of poverty is rising, and particularly the level of child poverty is rising here. And in that context, access to justice has never been more important. And I guess in terms of law centres, I think we need to stay responsive to where there is unmet need. I think we do need, a challenge for us is to look at new ways of developing our services. I think we have a job to do in terms of working within and across communities to characterise problems as legal problems which are capable of resolution. And for all of that, what really matters is that everybody has reliable access to this type of service. And to have reliable access to that type of service, then there simply needs to be in place reliable resourcing for this type of service, because it matters. And we all work within that sector, so we all know the challenges of year on year. But the resolution to the problems that people experience are do not fall within those nice neat little time frames and boxes that our resourcing certainly does. So I think going forward in terms of I think there is an opportunity to think about what a different created future looks like, how law centres can work in solidarity within and across communities, and how do we, this is something that I know has been around for a long time, how do law centres, and I know it happens across all jurisdictions, but how do law centres really harness the passion and the enthusiasm of the next generation and pro bono support from across others within the legal profession to really create that future where everyone can have access to justice.
Terrific, thank you, Ursula. Rose, I'm going to ask you to pick up this conversation now, and at Northside, you're moving into slightly new directions. Your focus is moving into the area of climate action and how this affects local communities. So do you see new areas of work or new themes of work emerging? And what are your views on the work or the relevance of community law centres in the future?
Yeah, so while there will undoubtedly be a long-term impact from COVID in the area of housing, employment and other areas, and this will disproportionately impact the communities that we work with, for me, the biggest and more long-term challenge is the climate crisis. And to some of the people listening today, this might sound unconnected to the work that CLM does in areas like employment, equality and housing, but it really isn't, because the climate crisis is having and will continue to have a profound effect on all aspects of human life and human rights. Climate change threatens the right to life, health, food, water, property, education, work, culture, adequate standard of living, adequate and secure housing, and a healthy environment. And it's also increasingly recognised that individuals and communities experiencing poverty, social exclusion and inequality are disproportionately affected by climate change. For example, certain groups, depending on where they live and where they can afford to live, are more likely to be affected by poor air quality, which we know from the Environmental Protection Agency reports contributes to the premature death of 1,200 people in Ireland every year. There's also the risk that climate action policies themselves will exacerbate existing inequalities through job loss with the closure of certain industries, and energy poverty, particularly with members of the travelling community, with the introduction of carbon taxes and other measures. That's not to say that climate action measures shouldn't be taken, but they must be developed with due regard for climate justice and just transition. So I strongly feel that climate justice should be worked on by all community law centres and indeed any organisation working in the social inclusion or equality space. And it's particularly important when you consider that, well, firstly, that communities experiencing disadvantage are not currently engaged on the issue of climate change. So while awareness of climate change is increased, other social and economic concerns perceived as more immediate are given priority. So, and with our most recent general election in February this year, the exit polls showed that climate change was a key issue for only 6% of voters, with housing, homelessness and health ranked in priority. And in the aftermath of COVID, it's likely that the public appetite for climate action will be further diminished as concerns about jobs and economic security come to the fore. So it's essential that communities that are served by organisations represented by this panel are engaged on this issue, otherwise they won't have a voice in developing the response to it. But secondly, climate action while it has the potential, as I mentioned, to exacerbate existing inequalities, there is also the potential to consider many of the issues faced by communities experiencing disadvantage. So having that sense of ambition and that sense of fairness and that sense of open-mindedness that we've talked about and Ursula just mentioned. So in looking at climate action, there's also the potential to look at workers' rights in energy poverty, health and housing and transport. And this would have the significant benefit of dealing with wider issues of inequality. And to do this, again, we need to make sure that we have the voice of the communities that we work with and to make sure that they're engaged on this issue. And finally, it's crucial that public authorities are held to account when they make unlawful decisions that irretrievably damage our environment. So communities need to be empowered to fight for clean air, clean water and a healthy planet because the environment isn't able to do so. So for me, the role of community law centres in this is using our normal models, so the community engagement, education strand, legal advice and representation, and law reform. We need to engage the communities we work with on environmental end of the world issues by making the connection with end of the month issues. And we also need to empower those communities to use the law and ensuring that their voice is heard. So in CLM, we are expanding our work into the area of environmental justice by setting up a Centre for Environmental Justice in January to engage and empower communities experiencing disadvantage on environmental justice issues. So we're going to do this through a community engagement programme, capacity building training, legal advice and information. So a key element will be ensuring that community engagement is carried out in a collaborative, meaningful, accessible, participatory and practical way. So we'll do that by making the connection between health, housing, jobs and the environment. We'll collaborate with organisations in the equality and social justice sectors to build on their networks and to reach the hard to reach groups that they work with. And we will give individuals and groups practical tools such as the Aarhus Convention to empower them to have a voice in environmental matters. Strategic litigation, for example, looking at the disproportionate impact of air and water quality in certain groups, or the lack of climate adaptation for families living in flood risk areas, will also be crucial elements of the project, as will law reform. And already this year we have carried out law reform on the Housing and Planning and Development Bill, which looked to restrict environmental democracy rights. But also only last week we did a submission on the Climate Bill 2020, which contains really weak provisions in relation to just transition. Well, no provision in fact in relation to just transition, but very weak provisions in relation to climate justice. So given this intersectional focus, the project fits within CLM's strategy and mission, and the need for the project has been thrown into sharp relief by the current crisis. The inequality that we've all spoken about of experience of COVID has arisen because of vulnerabilities of certain groups as a result of their health, their precarious employment or housing situation, or because of unequal access to environmental benefits like green space. And the response to this pandemic has also demonstrated the need to ensure protection for those most vulnerable to its effect. So 45 years since we've been set up, we're now at this critical juncture where we're looking at the two defining issues of our time, I think, COVID and looking forward to the climate crisis.
Okay, two very big issues for the future, and I'm sure you sound like you're getting very well equipped to deal with both. Sean, I'm going to ask you the same question. You mentioned in the first part of the discussion the successes of the law centres movement in the United Kingdom as being the establishment of a rights framework. And are you concerned that future challenge might be an erosion of the rights framework? Ursula has mentioned this in her presentation to us. And what are the other challenges that you might see for the law centres going into the future?
Well, I mean, as I've alluded to and what's been said before, I mean, we do have quite a lot of a plethora of rights and statutes to enforce those. But I think the government's given us a lot of tools to enforce rights, but it's taken away the funding effectively. And as been alluded to in the Unison case, without proper funding, it's very difficult to to give the principle of access to justice any real meaning. I think that's what's happened over the last, certainly the last 10 years. We've seen huge areas of legal aid suffer from scope cuts, which have impacted disproportionately on the most vulnerable communities that we interact with every day. But we have to keep battling that argument. I mean, this year, the government's thrown lots of money at us in our sector to try and address some of the difficulties with the COVID. But obviously, coming down the road, we're all conscious that there could be a tsunami of public spending cutbacks, basically, which will only fuel all the problems that we've witnessed over the last decade. And clearly, we don't operate in a vacuum. I mean, we're all conscious of the economic and social dislocation, all the kind of culture wars, the political polarization that afflicts certainly the UK and America, as you know. And these are all kind of problems that stem from people who are kind of marginalized, and lots of people who are disproportionately affected by the scale and the pace of economic and social change, are looking for a voice. And I think it's really important that certainly the law centre movement is there to articulate that voice. And I think we do that very well. We've done it through our campaigns and through our casework. And it's really important that we stay there. I'm also conscious of the fact that we need to kind of renew and re-energize our sector, because clearly we want to bring in a new generation of lawyers, I think. And I think that's really important. I think we've always been quite good at that, but clearly one is conscious that the fact that the cutbacks in legal aid means that it's quite difficult to attract a new generation into our sector at times, because clearly they can find more prosperous employment elsewhere. But I think it's really important that we invest time, and we certainly do that in our own way, to bring in new blood into the sector. But I think that builds and consolidates all the achievements that we've discussed over the last 50 years. I think, I mean, the funding future is uncertain, but I think we have been very good at making the argument, I think. If you think about how our sector started, the whole legal aid field, the scope areas that we work across have been expanded over the last 50 years. Started off principally as housing, and then was immigration, and we've kind of extended into all areas of civil law, and occasionally even criminal law. And I think it's really important that, you know, we're there. I think a lot of at the moment, because of the lack of sufficient providers within the sector, the government relies, and particularly in the Ministry of Justice in the UK, relies on our network to deliver advice services for the most vulnerable communities, has to be said. And I think going forward, what I'd like to see in the next 10 years is that the efforts that the government have made to fund us at the moment in the current cycle, that continues going forward, and that there's a more sustainable funding model put in place, so that we don't have these kind of keep having discussions about being resilient and all the rest of it. We're a key part of the whole principle of the framework of access to justice, and making sure that, you know, people are able to make a full participation in civil society, basically. And I think also going ahead, just to the challenge, if you think about it, this pandemic has kind of highlighted, apart from the immediate socio-economic disparities and the entrenched inequalities, there's also a new demographic of people coming through who never used our services in the past. Certainly we've seen that in employment, and where people who've been coasting through life quite comfortably, but suddenly been affected by this kind of crisis. And it has an enormous impact, not just on the individual, but on the whole quality of family life. And I think that creates an enormous social cost to the state. And I think it's really important that the state puts in place sufficient resources so that these things can be prevented. I think one of the real achievements of our movement is that we prevent problems escalating, and that in turn saves upstream and downstream costs to the sector, the state. I think it's really important that the government takes notice of that going forward. So overall, I'm quite optimistic that, you know, our movement will continue to build on the achievements, but one can't overlook the challenges going forward in terms of the wider political developments that we see taking place around us.
Very good. I'm delighted that you have concluded on such an optimistic note, because I suppose that brings us towards the end of our panel discussion today. And I'd really like to thank all of you for the time that you've taken and the thought that you have put into your contributions to the panel today. I know from reading the comments that the participants have kindly shared with us that they've really valued your insights as well. And I would particularly like to thank you all for sticking very, very well to the time slots that were allotted to you. And we're actually bang on schedule, which for an event like this is quite wonderful. It made my job very easy, and I'm going to take all the credit for it, for keeping you on track. This was an absolutely great session. The comments that we have coming in are, not surprisingly, overwhelmingly congratulating Community Law and Mediation on achieving their 45th anniversary. There's good wishes coming in from all over, really, but particularly we've had good wishes from Michael Farrell to you. We've also had good wishes from the CEO Eilish Barry at FLAC on behalf of the team there. We've had good wishes coming in from Ballymun Community Law Centre, and we have good wishes coming in from your volunteers, past and present. So there's a lot of goodwill out there for community law and mediation, and I think for community law centres across the 3 jurisdictions. It's interesting from the comments as well that, you know, really that issue of employment and unemployment, it really seems to be spiking at the moment. And I think, you know, the consequential need with regards to welfare advice and so on is a particular issue that seems to be emerging for this time. So thank you to everybody who's been watching today as well. And thank you to all of you who have made comments with regards to the presentations that you've heard. Some common themes have emerged from the discussion today. I think Ursula kind of really pinpointed it when she said it's survival, it's resilience, it's tenacity. For law centres to have not only survived, but to have thrived over the last 50 years or 45 years is really quite an accomplishment. You know, a law centre that started out as a 2-year pilot project to still be alive and vibrant and relevant is extremely important. Similarly, the law centres in London and the strength of the law centres movement in England. But I know the struggles that community law and mediation have gone through over the years, having lived them. But you know, the vibrancy of the centre there and the forward-lookingness of community law and mediation, and to still be there and to still be hosting events like this is a terrific accomplishment. The other themes that are emerging from the conversation today is the ability to be able to respond to external challenges, and the particular external challenges of this time that this historic time that we're living through. COVID, Brexit, climate change, really big issues that are going to affect everybody. And to have law centres who are flexible and able to meet those demands is extremely important. The responses to disadvantage and to inequality are needed now as much as they were needed 45 or 50 years ago. There are still structural inequalities in our society, and law centres occupy that really important space of trying to adjust or readjust those structural disadvantages and those inequalities, and try to step into that gap. And another theme that's really clearly emerged, and one that I wasn't expecting perhaps, was the witnessing of that potential for a different and more equal future that we have seen in this very recent past. And that shows us that the opportunity is there and that it can be harnessed. And that is perhaps a really exciting step in the evolution of law centres over the years to come. And the final theme that I would have picked up from today's panel discussion is how law centres really occupy that space of being that voice for change, that connection between an unequal or disadvantaged community, and enabling that community to be able to articulate a call for a rebalancing of rights, a redressing of inequalities in a way that can be understood by the people who make decisions. And that voice is an extremely important and powerful voice to have in the present, but it's also going to be equally as important to have for the future. So congratulations, Community Law and Mediation, you're celebrating 45 years. We're looking forward to the golden anniversary already, which will be in about 5 years' time. And I certainly hope, and I feel really hopeful today, having heard this conversation, that we're entering into that golden age, perhaps of law centres, not just in Dublin or in Ireland, but in Northern Ireland and in England also. Law centres are still needed, law centres are still relevant, and law centres are perhaps now more important than they ever have been before. So thank you for inviting me to participate in this panel discussion. And now I'm going to hand over to Rose, who is the Chief Executive of Community Law and Mediation, will have the final word.
Thank you, Colin. And I suppose I just want to conclude by saying what a sense of privilege I feel to be on the panel today and to be with such great company, but also to be working in CLM and doing the important work that we're doing. I also have to say I feel a slight sense of relief that we've had no major IT hitches, which is great. But I've learned a lot today and there's been a lot to think about. So thank you to you all, and thank you, Colin, for your time too. But I also want to acknowledge everyone who's attended today and who supported CLM and worked with us over the years. You know, the C in CLM, the community, has many layers to it and includes also the community of volunteers and supporters who believe in the importance of our work and in using their skills and their time for the people who need it. So to you all, thank you very much and have a very good day.